Now, from the Signature Bank Studios, this is Chicago's Morning Answer with Dan Proft on AM 560. The Answer.
Top of the morning, Dan Proft here. So, returning to the Birthright Citizenship holding the Supreme Court promulgated yesterday, Roberts writing for the majority, tracing his argument back to English common law and bringing it all the way to present. That basically concluded that if you are born on American soil, then you are an American citizen. Some divided opinion among conservatives as to the impact of this case. For example, our colleague in sound, Hugh Hewitt, Fox News contributor, had this to say.
I'm not surprised by any of these decisions. I would have agreed with, were I in the court, with all three of them. I think the Chief Justice has hit it out of the park on the birthright citizenship issue, and we finally have a decision that lays to rest this endless debate that text, history, and tradition, in fact, affirm if you're born in the United States, you're a citizen.
That's not the feeling that Molly Hemingway had after hearing the court's opinion and reading the majority opinion authored by John Roberts. She compared it to some of the worst cases ever decided by the high court, like in the country's history.
This is an absolutely important and devastatingly bad decision for the future of the country. This decision that John Roberts authored is bad on the level of Dred Scott or Roe v. Wade. It's that bad. Previously, we had a policy of saying if you have parents who are here illegally and you're born here, you might be considered a citizen. But today is the first day that the Supreme Court has ever said that's a constitutional right. Justice Alito had an excellent dissent as well. He said he thinks this was a very important decision and very wrongly decided. He goes through in an originalist manner, meaning what was the original meaning of the 14th Amendment, and looks at how this Roberts decision came to its reasoning. And it's frankly pretty absurd. Justice Thomas also did a great job. The 14th Amendment to the U.S. Constitution says you can't deny citizenship on the basis of race. That's what it was for. There were people who were trying to deny citizenship to children of formerly enslaved people. And that's what the 14th Amendment was for. It was never saying you don't get to have any say in who's a citizen. And you look at how it's not just this case. It's so many things. Anything that Americans try to do to restore their borders, to determine who gets to come here. You have rogue lower court judges just throwing it out and saying you don't get to say. This cuts to the issue of sovereignty, who we are as a people, whether we will even exist in a few decades. So this is a very important decision. And unfortunately, for an otherwise pretty good term, a really bad end to that.
In the majority opinion, Roberts held, I'm quoting, what the court held in Wong Kim Ark was simple. The Citizenship Clause, 14th Amendment, incorporated the common law and granted citizenship to nearly all children born in the United States. The exceptions are few, basically children of foreign diplomats who have immunity from U.S. law, and thus cannot be said to be under the jurisdiction thereof. For more on this, pleased to be joined by Professor Richard Epstein, James Parker Hall, Distinguished Service Professor Emeritus of Law and Senior Lecturer at the University of Chicago, and author of The Myth of Birthright Citizenship, in case you were wondering where Professor Epstein came down in this case. Professor Epstein, thanks for joining us. Appreciate it.
It's a pleasure to be with you, Stan.
Well, so, would you go as far as Molly Hemingway went in comparing this to Dred Scott and Roe?
No, it's not as bad as that, but it's utterly incompetent and completely dishonest. I mean, it is, in terms of a technical matter, an absolute intellectual mess. what the Chief Justice starts to say is, we are doing in this particular case, I'm now quoting, is affirming now and then the right to freely participate in our political community to every free-born person born in this land. It didn't say that at all. I mean, what you have to do is to understand that the opinion here was very convincing on one thing, that is the 14th Amendment. The children of slaves were citizens along with their parents. But it had nothing to do with foreign people coming into the United States at all. And in fact, what happened was, if you look at the history of the 14th Amendment, the only reason it got passed was that it made it very clear that the amendment did not confer the right to vote on American blacks or on women. And indeed, in 1874, there's another case called Minor and Happersett, not cited by the Chief Justice, which holds exactly that. What it says is that the definition of citizenship is a promise of loyalty in exchange for protection of the sovereign. Voting has nothing to do with it. And so it's hard to sort of treat this as a universal call for automatic citizenship of everybody from overseas if it has that particular view on voting. And also, I mean, there is a statute involved. The Chief Justice said this is a common law matter. It's just flatly wrong. If you go back and you read the stuff in England, naturalization is something that can only be done by a parliament. And so it's a statutory matter. And the English statute actually did allow for birthright citizenship in a relatively inconsequential consequences. But the American situation under the 1790 and 1795 Naturalization Act basically said you have to go through the federal system. That's Hamilton speaking about the Uniform Naturalization Clause. And the first words of that clause are, any free white person may apply. That's hardly a statement of universal belief in citizenship. And in fact, that clause in that form remained in the Constitution, rather in the statute, until 1870, which was 4 years after the Congress had passed the 14th Amendment. And so what the defendants of birthright citizenship are claiming is you get this stuff automatically when the most you could get after the statute was the right to apply. And there were some very serious conditions on that. And indeed, 90% or more of the 1870 Act was tightening up the requirements for proof of naturalization because of what was perceived as widespread fraud on this particular issue. So everything he writes is absolutely make-believe. Another thing is, what do we mean by the word jurisdiction? The New York Times, this is really simple. It's only simple to a simpleton. It turns out, if you go back and read the very sources they were on, Blackstone is crystal clear that the word has two meanings, and you have to separate them. One meaning is what he calls local allegiance. We would call it jurisdiction. And that means that if you're in somebody else's country, you have to abide by their civil law and their criminal law to be punished like anybody else. But it doesn't give you the right to have citizenship for your children. And said the moment you leave, this is gone. The other form of allegiance, which he called natural or full allegiance, is the fact where you owe complete loyalty to the citizen, to the sovereign. And there, in fact, you are a citizen by birth, or if the statutory provisions are satisfied, by statute. The American statute is completely different from the English statute, and there's a very good reason why. Two reasons, actually. One, we're a federalist situation, and in the original Constitution, nobody thought that they could limit the way in which the states resolve citizenship questions with respect to the states. And there are a whole host of cases out there which ask such questions: can you inherit under state law? The answer is sometimes yes, sometimes no. The same question: could you vote in a local election? Could you serve as a local state officer? Those were the questions that they did. There was no birthright citizenship involved.
Well,
go ahead.
Well, so since the court decided not to go the Kavanaugh way and essentially, sort of the middle way without declaring it a constitutional right, upholding it essentially in pertinent part, but without declaring it a constitutional right, so providing Congress more latitude. If you're Trump administration and Trump administration allies, You've had some legislative proposals from Bernie Moreno, senator from Ohio, suggesting ban birthright citizenship, but that obviously would run afoul of this decision. You have a congressman from Tennessee who's proposing no admittance to pregnant women to deal with the birthright tourism issue. And then, so there are some legislative, and the other thing too is the suggestion that there needs to be some statutory fraud language associated with birthright citizenship when you're coming to one of these places, paying a lot of money to stay at a quote unquote maternity hotel in a place like California to have your baby, and then you and your baby pull out as soon as the citizenship has been established. So that's a fraud. It could be a fraud issue too. So I mean, just in terms of thinking about how to address this legally and then perhaps constitutionally, what would some of your suggestions be, or your reaction to those proposals?
Well, I think, in effect, the thing that has to be done is something like the ban. Let's put the sense on the size of the problem. It turns out the last year for which we have reliable data, which was 2023, there were 300,000 birthright citizenships in the United States out of roughly 3 million births in this particular country. So you're talking about 10% of the total.
Right.
Now, when they go back home, they still have dual citizenship, and it's not even clear that they keep their American citizenship unless they come back to the United States. And the laws about how you recognize people who are either born abroad or raised abroad for an extensive period of time is a subject that you can deal with the Naturalization Act. The problem here is it has two sides. In 1698, the English passed a very important statute which said that English citizens abroad, their children, when born, became English citizens, because otherwise you'd never get anybody to serve with his wife in India or someplace. And that power was explicitly reserved to the federal government in all the Naturalization Act. There's a book as long as your arm which starts to deal with these conditions. And the general rule with respect to naturalization is it's regarded as a plenary power of the United States. Indeed, it was precisely that meaning, which, taken from Thomas Jefferson, no less, which meant that the original statute was never challenged on constitutional lines when it said that the only person who are eligible for naturalization are white people, free white people. All this issue is completely ignored by the Chief Justice. And in terms of what's going to go on next, you're going to see the kind of reaction that Molly Hemingway had by large numbers of people. Once these numbers become clear, the Chief Justice never addresses this issue. He did so on oral argument and made a fool of himself when he said that somehow or other, in the late 19th century, nobody cared about Chinese influx into the United States. He never knew anything about the treaties and all the elaborate arrangements. It was a number one issue in this country at that time, even though there were fewer people who came, and they came by boat. And then he says, well, the Constitution never changes. Of course, it did change, because what happened is immigration was, at the time of the founding, exclusively a state problem, and it was very aggressively policed by the state. And in 1885, when the Chinese exclusion cases, all of a sudden it became a federal constitutional issue, our unchanging constitution. And by 1891, we have an exhaustive immigration act talking about something for which there's no original authority. So, I mean, the opinion was staggering, but you're right. What is going to happen is this is such a bomb. And it's not people washing up on the shores they're worried about. It's the birthright tourism that I think the proposal to say that no person can come into the United States if she's pregnant. And I think it's also require any woman of age, if she wants to come in, not only to sign papers, but to post a bond to make sure that if she does have the child, she leaves. I think these things are constitutional, unless they say the Equal Protection Clause changes it. But this is, again, one of the wild mistakes of the original Constitution. The basic question of equal protection applied to all persons. It had nothing to do with citizenship. It had to do with two things. It had to do with giving you a fair trial, due process, and using the same law for an alien that they use for an American citizen when it comes to meting out punishments for what's going on. And that's why
So if you did a birthright citizenship ban or some sort of like you said, I mean, it would basically be like pregnancy testing if you're talking about not letting pregnant women in, or as you mentioned, signing a waiver with a surety bond if you did. I mean, so you think that would pass muster it would per this Trump versus Barbara decision, despite the fact.
Well, let me put it this way.
Why? Because it's a predicate. Because it's before you get here. That's why it doesn't run afoul of this interpretation.
Because essentially, if you read all the other cases, including those written by Horace Gray, it says the United States has the absolute power to exclude anybody from this country, no questions asked. And then there's a huge debate if somebody has been admitted to the United States, can you deport him without a hearing? And if you have to give him a hearing, what kind of hearing do you have to give him? That issue split the court in 1890. It splits the court today. But you're here on the right side of it.
Well, and the one thing, too, is at worst, it may be something that is litigated up to the Supreme Court and they grant cert and we revisit this.
Well, that's also possible. Look, this decision is so intellectually incompetent. I mean, everybody that you talked about mentioned the consequences. Well, Mr. Hewitt does not know what he's talking about when he says that he knocked it out of the park. It is the most inept opinion on a major subject that I've ever read in my life. It's just absolutely wrong. And what happens is it will not withstand the test of time, notwithstanding the fact that everybody praises it as a form of originalism. It's a framers' constitution. I mean, let's be very clear about it. The framers had two things in mind. They wanted to overturn Dred Scott, and they wanted to preserve segregation. That's what they wanted, if you go back and read everything in the book. And what galls me personally is Ben Flowers and I wrote a brief. The book was available to the Supreme Court. Justice Thomas relies on both in one of his dissents. The Chief Justice never addresses any of the arguments there. How could you write an opinion about the Naturalization Act which you never mentioned? I mean, this is absolute fantasy. And it will come back that this opinion is one of the sloppiest opinions that's ever written. And everything he writes in it gets it wrong. So he says we have a systematic adaptation of the English rule on birthright citizenship. It's crazy. What happened is the moment the revolution began, there was a huge debate as to whether or not American citizens could remain loyal to the crown,
right,
or whether or not they could be independent and become American citizens. And this thing is litigated up and down over the line. And in the end, what they do decide is that it's an option. And of course, if you go back and you read the English position on that, as Blackstone said, citizenship is something which, when given to you, you can only lose by getting the consent of the crown. You cannot renounce your citizenship under the English rule. And that immediately disappeared by the time you got to the colonies, long before we had a debate over the Naturalization Act. And so everything he says about the common law is just beyond incompetent.
Well,
it's an amazing tribute to the intellectual ingenuity of the Chief Justice.
Yeah, well, and perhaps it's another example of politicians in robes, and that maybe it's less intellectual infirmity than it is a political cowardice, maybe, too. That perhaps could play a role.
Who knows? I don't figure out his motivation. The work that he put out is utterly wrong. I mean, in so many ways. I wrote this long piece when he gave the oral argument, talking about everything that was said. And everybody on both sides of the case did not understand what the issues were about, because they did not go back to deal with the Naturalization Act, because the government didn't want to face the racist implications of those acts, and the defendants knew if you took them into account, you'd never have an alternative path of automatic citizenship if, in fact, you had a very rigorous process for naturalization. And that's the simple story.
Professor Richard Epstein, James Parker Hall, Distinguished Service Professor, Emeritus of Law, Senior Lecturer at the University of Chicago, and author of The Myth of Birthright Citizenship, which you just got the Cliff Notes version of. Professor Epstein, thanks so much for joining us, as always. Appreciate it.
And thank you so much for having me.
And he joined us on the AlphaWealthGroup.com answer line.
The stories you need to know to start your day. This is Chicago's Morning Answer on AM 560. The Answer.
Each morning, the newsmakers and the newsbreakers shaping today's conversation are heard on the AlphaWealthGroup.com answer line on Chicago's Morning Answer. When you need answers about what's happening in your world, you turn to AM 560 The Answer. And when you need answers about how to prepare for and protect your retirement, you turn to the Alpha Wealth Group, now the proud sponsor of the AM 560 Answer line, right here on Chicago's source for news, opinion, and insight. AM 560 The Answer.
At Audi Morton Grove, your complete satisfaction means everything to us. As a family-owned dealership, we're dedicated to making every visit your best experience. Whether you're shopping for a new Audi, visiting for service, or simply taking a test drive, you'll always receive the personal attention and exceptional care you deserve. Visit us at 7000 Gulf Road in Morton Grove or online at AudiMortonGrove.com. McGrath Auto. Service, value, reputation. That's the power of McGrath.
Making the switch to a new communications and IT company may seem like a big ordeal, but if you're not getting the reliable support, consistent internet, and secure solutions your company needs, meet Access One, your local Chicagoland IT experts. Access One has been powering Chicago businesses with secure, reliable IT solutions for over 30 years from our headquarters right here in the West Loop. Whether it's VoIP phones, dedicated internet, managed cybersecurity, cloud backups, or 24/7 support, Access One is here for you.